You understand the terms of that plea agreement?
Yes, I do.
Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
Your Honor, I just looked at the complaint. I believe he would be pleading, it just switches the alleged victim. He'd be pleading guilty to count 2 and dismissing count 1 with the half floors.
Good afternoon. We're on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. We have a case scheduled for a jury trial tomorrow. I told the parties wanted to convene on the record this afternoon in People of the State of Michigan versus Aaron Field. It's filed 24-6914FH. Counsel, you want to place your appearances on the record?
Melissa Goodrich, Sheboygan County Prosecutor.
And good afternoon, Your Honor. James Gilbert here on behalf of Mr. Field, who's seated to my right.
Okay, good afternoon, Mr. Field. All right, so Mr. Gilbert, do we have a change plan?
No, we do, Your Honor. If I may present to the bailiff to present to the court, we do have a signed plea agreement.
Okay, Mr. Field, would you please stand and raise your right hand for me as best you can? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Put your hand down. Mr. Field, the guilty plea hearing is an important event. It includes the waiver of constitutional rights you have, including to a jury trial that's scheduled tomorrow. We got all the jurors ready to come. So I want you to listen very carefully. And if you have any questions, go ahead and ask me. We're happy to answer those questions. If you need more time to talk to Mr. Gilbert, you just let us know. We're happy to give you that time. Do you understand that?
Mm-hmm. Yes, sir.
All right, now I have to advise you the maximum penalty that you could face for the charge you're offering to plead guilty to is count 1, a charge of aggravated stalking. That is a felony crime, punishable by a maximum of 5 years in prison and or $10,000, or probation for any term of years, not less than 5 years. Do you understand that maximum penalty?
Yes, sir.
All right, and that, as I understand, was committed while the other felony was pending, for which you're serving a sentence in the Department of Corrections. So that would be discretionary consecutive sentencing to the sentence that you're already serving. Do you understand that, sir?
Yes, sir.
Right. Did you read and understand the rights listed on the advice of rights form?
Yes, sir.
And you signed that today?
Yes, sir.
Do you have any questions for me or Mr. Gilbert about any of those rights?
Negative.
Do you understand if you plead guilty, you'll give up those rights and won't have your trial tomorrow?
Yes, sir.
And is that what you're choosing to do today?
Yes, sir.
If I accept that plea, you give up any claim that it was caused by any threats or by any promises outside of what's put on the record today. Do you understand that? And also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. The types of issues you could raise on that application would be very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, sir.
The plea agreement provides in exchange for your plea of guilty to count 1 as I outlined, the prosecutor will dismiss count 2 as well as the habitual notice. There's a sentence agreement that any incarceration I impose would not cause your release date to be beyond December 31st, 2026. By my memory, that would anticipate some degree of consecutive sentencing, because your current out date, I think, is what, in November?
11/8.
Okay. Okay, and there's also a recommendation from the prosecutor that the court would not object to your entry into the SAI program if the DOC determines you eligible for that. You understand the terms of that plea agreement?
Yes, I do.
Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
Your Honor, I just looked at the complaint. I believe he would be pleading, it just switches the alleged victim. He'd be pleading guilty to count 2 and dismissing count 1 with the half floors. That makes Mr. William Fitzgerald the alleged victim versus the other alleged victim.
Okay, well, the plea agreement said guilty to count 1, dismiss count 2. Do you want me to flip-flop those?
That would be fine. They're the same charges.
Okay.
Yep.
So I'm going to handwrite, change the counts on the form.
I just caught that.
Same penalties though, Mr. Field. All right, so Mr. Field, I want to make sure you understand a couple things there. The sentence agreement for basically no more than a few more weeks on your out date, that's not binding on me.
Sure.
If I didn't follow it though, you'd be allowed to withdraw your plea unless you engage in some misconduct between now and the sentencing. Do you understand that?
Yes, sir.
Now, the recommendation from the prosecutor for your participation in the SAI boot camp program is not binding either.
Sure.
But if that doesn't happen, you are not allowed to withdraw your plea. It's a recommendation only. Do you understand that?
Okay.
So there's two things that would need to happen beyond their recommendation, is that the Department of Corrections would have to determine you eligible, and I would have to allow it. I'm given an opportunity to allow or to object to it.
Sure.
As I sit here today, I don't know entirely what I would do with that. It'll depend on what I read in the pre-sentence report, and which will include how you've been doing since you've been inside. Do you understand all that?
Yes, sir.
All right. Other than the plea agreement, has anybody promised you anything in exchange for your plea?
No.
Has anybody threatened you to make you plead?
No.
Is it your own free choice to do so?
Yes, sir.
Knowing all this, how do you wish to plead to the charge in count 2, aggravated stalking?
Guilty.
Mr. Gilbert, would you assist with factual basis?
I'd be happy to. Sir, can you state your name for the record?
Aaron.
In June 14th of 2024, were you in Sheboygan County?
I was.
And was also a gentleman by the name of William Fitzgerald in Sheboygan County.
Wolverine, yes.
Okay, in the Wolverine.
Wherever, yes.
Okay, he was in the Wolverine area,
I believe so.
but you were located in Sheboygan County,
Yes.
and you began texting Mr. Fitzgerald,
Yes.
and many of those texts were inappropriate.
Yeah.
And there was multiple pages of text.
It was back and forth. Yes, sir.
Okay, but you would agree that the texts were in a harassing manner?
It was harassing and insulting.
Okay, and again, that happened while in Sheboygan County, and,
Yes, sir.
there was multiple of those texts during the course of that day.
You.
I have no further questions, Your Honor. Thank you.
Well, that would establish stalking, but my understanding from the felony information for the aggravated stalking, one of them has to include one or more credible threats.
One of them did. One of the texts did say that you would no longer be here.
I said,
You'll be gone, or
I
something.
said that you won't be around long.
Okay.
Okay.
Yep.
All right, Mr. Gilbert, you satisfied with that factual basis?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
And Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I am not.
Ms. Goodrich?
No, Your Honor.
And Mr. Gilbert, your judgment is the court fully complied with the requirements of MCR 6.302.
With the court has. Thank you.
Ms. Goodrich?
Yes.
All right, Mr. Field, as I mentioned, you're writted up to be here. We have jurors summoned to arrive tomorrow to do the trial. So I don't want you to feel any kind of pressure that you have to do one thing or another today. If you want to go forward with the trial tomorrow, that's your absolute right to do, and we're happy to do that for you. So do you want me to accept this plea and you're waiving your right to a trial?
I believe the plea is fair, sir.
Okay, and you want me to accept that plea then?
If you would.
Okay. All right, well, Mr. Field, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. I will require an updated pre-sentence report so that it'll include, as I mentioned, some information about your adjustment while serving the sentence in the DOC. But I think we do want to schedule it as soon as we can for several reasons in the plea agreement here. So we'll put it on for the November 4th docket at 2:50 in the afternoon. I think we'll be able to get a pre-sentence report done in time for that. And Mr. Field, you want us to reach you back in person for that sentencing? That's your absolute right.
If you want me up here, I'll come, but if not, I can do it from Zoom. It's up to you.
Well,
Whatever you like.
legally, it's up to you. You have the right to be here, and there's no problem.
Okay.
There's no problem doing the writ. No problem at all. Sometimes people prefer not to leave where they're situated for all sorts of reasons, and they want to do it by Zoom. So I'm not asking you to waive your right to be
Okay.
present in person. I'm just asking you if you have a preference to do it by video.
I think I would just do it by Zoom if that's okay.
Okay.
You know,
All right. Well, we'll go ahead and do that. We'll schedule it for a video hearing if that's your preference then.
that's okay.
Let Mr. Gilbert
It's
know.
up to you.
Yeah, it's totally up to you. It's
Okay.
fine.
All right.
Let Mr. Gilbert know if you change your mind so that we
Okay.
can prepare the paperwork to get you here in person.
Okay.
Anything further from the people?
No, Your Honor.
From the defense?
No, thank you very much.
Okay, that'll take care of that case. There is another case on for tomorrow, so let's go off the record and see what we're doing on that one. And, I'll get you that. All right, back on the record and continuing People v. Warner 25-7004. Ms. Goodrich, the defense has objected to OB4. Do the people have a response?
Yes, Your Honor, as to both OB4 and OB10, the people seek an adjournment to consult with the victim about possibly making a statement.
Okay. And Mr. Andraki at the bench, I described that the court rules allow an objection to the scoring to be timely made at sentencing or even in a timely filed motion for resentencing. So I don't require them to be filed in writing beforehand. I know some courts do, I don't. But that sort of the safety valve I think I have to provide the people is that if they didn't have advance notice and they want an opportunity to respond either with briefing or with a factual record, I have to give them that opportunity. So it'd be my intention to continue this matter to October 21st at 2 p.m. Do you have any objection to that, Mr. Andrack?
No, Your Honor. We had discussed this, and I advised Mr. Warner of what's happening, and we don't have any objection to that.
Okay. And do you want to also state on the record what your objection is to OB10 so that we know?
Yes. I suppose just to be completely clear about OB4 too, it is not scored for the accosting charge. It's only scored for the using a computer to commit a crime charge. And in regards to OB10, which is scored under both of them, this is predatory conduct. In this case, as far as using a computer to commit a crime, it would not be the proper crime to charge that with. I believe if any points were to be scored, it would be on the accosting, but not necessarily on just using a computer to commit a crime, as there is no predatory conduct involved in the use of the cell phone, I guess is what it was, is to send text messages and so forth. But as regards to OB10, perhaps more specifically, there's no facts here. Again, the prosecution has proved by preponderance of the evidence that there was predatory conduct involved. Is there a relationship between Mr. Warner and adoptive niece? Yes, in that respect. But as the OB10 makes clear, the presence alone is not enough. And ultimately, there was no exploitation because the victim did not agree to send him any material in return. She rejected his advances. So there could not have been an exploitation to begin with, since she wasn't exploited.
Okay, thank you.
That's my objection in that.
All right, so what I'll do is to give the people a fair opportunity to respond to those objections. I think they are on their surface, certainly not frivolous objections by any means. They would be they would have a significant effect on the advisory guidelines range and probably a significant effect on the court's sentence. So I want to give both, and it's a little bit nuanced between the computer crime and the accosting and how those guidelines should be scored. So I'll continue the sentencing hearing to October 21st at 2 p.m. I would allow either side to file a written memoranda or brief regarding those scoring issues, but I'm not going to require it. Just give you both an opportunity to do that if you wish. But then the adjournment will give you an opportunity to do some research and either present some legal arguments at the continued hearing or perhaps even to supplement the factual record, which is allowed at sentencing hearings by way of victim impact statement, testimony, or evidence. Anything further from the people?
There.
Anything further from the defense?
Only thank you for allowing us to reschedule this to 2. Other than that, no thank you.
Okay, thank you very much. We'll see you then.
Thank you, Your Honor.
Got Mr. Greenleaf and Mr. Nardoni.